owed, past payments, property taxes, or what have you, and you get to keep your property. That's kind of important to know that. I've seen clients let their house go to foreclosure, notwithstanding that they're taking the monthly payments and they're putting it into a savings account. And they're just letting that savings account increase. But because they're working with a foreclosure consultant or realtor or somebody else who's telling them not to make the payments, the house is sold. And then they come running to me and they say, I want my house back. And I say, that's unfortunate. Sometimes the legal solution is worse than the underlying problem. You're looking at a very expensive fix if you go to a lawyer after the sale. And the lawyer usually is very limited as to what he can do. So we'll take a break. He's going to switch the... Okay, now this right of reinstatement that I was talking about. It has an expiration date. All good things have an expiration date. When does your right to reinstatement expire? 5 days before the sale of the property. Now, if you come to me saying, hey, I'm 3 days before the sale of the property, I got my money, and the bank won't take it. I got the money to reinstate, but the bank won't take it. I'm probably going to tell you that's unfortunate, because they don't have a legal obligation any longer to do it. It becomes discretionary with the lender as to whether or not they're going to allow you to reinstate if you attempt the reinstatement within the 5 days before the sale of the property. Next slide. What can I do then? I'm 3 days before the sale of the property. What can I do to save my house? You can exercise your right of what's called redemption. Again, we're talking about a non-judicial foreclosure. If you find yourself day number 3 before the sale of the property, the bank won't let you reinstate. What can you do? You can exercise your right of redemption. What is the right of redemption? You have the right to pay off the loan in its entirety. 100 cents on the dollar. 100% of everything. And you get to keep the property. Now I recognize that you're thinking, well, if I had the money to do that, I wouldn't be in the pickle I'm in now. I understand. I'm just sharing with you that you're right. I did have a client one time come into my office, and she brought her father with her. And the father had a checkbook. Now, not everybody has a relative with a checkbook, but some people do. And if you're one of the people with a relative with a checkbook, the right of redemption might be a viable alternative. But the right of redemption, just like the right of reinstatement, has an expiration date. It expires with the sale of the property. What happens after the sale of the property? What rights does the home or the prior homeowner? Now you're a former homeowner after the sale of the property. What rights does the former homeowner have? Not a whole lot. Not many. What you're left with is you have to run to a lawyer. The lawyer's going to try and talk to the lender and convince the lender to let you reinstate. And if the bank isn't cooperating, then you hope that the lawyer can find some sort of violation of the foreclosure process. And if you can't, there's not a whole lot that can be done. Plus, you're going to have to, it involves filing a lawsuit, recording the lis pendens against the property to stop the bank from selling it. And now you're incurring a tremendous amount of money in attorney's fees. Not to mention, the bank, even if the bank did violate some law associated with the foreclosure process, and you win, you're back to square one with the foreclosure. The bank is going to say, reinstate, which means bring the loan current. So now you're not only paying your lawyer lots of money, you're having to come up with the money to bring the loan current. And most people, quite frankly, just don't have that kind of money. So once the property sells, a lot of the time hiring a lawyer just does not make economic sense. It's not an economically viable alternative. Well, next slide. This is a notice of default. This is what a notice of default looks like. Here again, a notice of default arises in a non-judicial foreclosure. And that's what one looks like. It will look like this. It'll come certified mail, it'll come regular mail, and it will be recorded at the county recorder's office. And somewhere in there, it's going to say how much money you owe. It's going to say you haven't paid. And you're going to say, I know that. Now, the next slide. This is a notice of sale. And here again, on the notice of sale, it's going to, here it has the date of sale, place of sale, and it identifies all the particulars associated with the sale of the property. Again, the notice of sale comes certified mail with the green card, comes regular mail, and it's recorded at the county recorder's office. Now, under California law, the lender is only required to mail it certified mail. So if you refuse the certified mail at your house, you're not buying yourself anything. Don't for a minute think it's buying you anything. The law doesn't require that the lender actually obtain your signature. All they've got to do is mail it. Okay, next slide. Now, I'm not going to talk too much about the judicial foreclosure because you just don't see them very often. But they are happening, and we have seen them. Why is it, then, would a lender judicially foreclose? Foreclose inside of the court. Any ideas?
If the owner filed bankruptcy?
No. Normally, not always, but normally, they think the borrower has stuff. They think he has stuff independent of the house that he can take, sell, and make money. What kind of stuff? Well, real estate, automobiles, investment accounts. Got a couple $100,000 in a Schwab account. Yeah, you might take a look at that if you can get at it. Bank accounts, businesses. You know, we had a client call us not too long ago where they had a sheriff show up at their restaurant and intercept the money as the customers would go to pay their meal bill. It was intercepted 100 cents on the dollar. People come in to pay a check. Oh, thank you very much. I'll take that. Creditors can do that kind of stuff. Again, if a borrower does not pay their lender, bad things happen. Bad things happen. Okay, next slide. This is what a judicial foreclosure looks like. You get a little piece of paper that says summons, and you have another one over here that says complaint. Complaint is another word for lawsuit. And usually it's served personally. The process server shows up at your place of work or your place or your residence. Do they ring the doorbell? Are you so-and-so? Well, yes, I am. Well, here you go. Thank you very much. And now you know you have been served with a judicial foreclosure. Next slide. What do you do if you receive one of those summons and complaints? Do not self-help. Run to a lawyer. Because you're probably being sued for a large sum of money. You're probably being sued for a large sum of money. Don't self-help. And the banks, ladies and gentlemen, they're tricky about this stuff. I was doing one of these workshops in Chula Vista through the library, and a gal in the crowd, raised her hand and says, I received a loan modification from the bank after the workshop. Can you take a look at it and tell me if it's a good deal?